second. Kara Mills on the record in BU 2025 TR 1670. State of Kansas versus Kara Desiree Mills. Jared Regier for the state. Kara Mills, are you present?
This is Alyssa's fault.
Is she taken off of the docket? I don't see her on there now.
I did remove her from the docket. It was a late removal due to some documents that the county attorney's office had filed.
Okay. Catherine Mann on the record in BU 2025 TR 1700. State of Kansas versus Catherine Lynn Mann. Jared Regier for the state. Catherine Mann, you want to start your audio and video, please? Catherine Mann?
I'm here. Sorry, my phone was having a hard time connecting.
All right. Well, Miss Mann, you're here on one count of driving while suspended, a Class B misdemeanor. If convicted, your sentence could be a fine of up from $100 to $1,000 and up to 6 months in the county jail. Are you interested in the diversion that you've been hearing about this morning?
Yes, ma'am. That would definitely interest me, and to update you guys, I'm currently been trying to get that resolved with obviously the suspension. I had the police officer falsify the BAC level, so I'm currently now having to go pay my storage unit hopefully today. I'm hoping I can get all the funds for that and then dig through all the paperwork because my BAC level was 0.12 and or 0.012 or whatever, and I have hypoglycemia. So legally, from what the attorney told me, is he wasn't supposed to breathalyze me and actually do a blood test because of that, and I just found out I was unaware hypoglycemic like 2 months ago. So I'm just trying to find that because he then wrote that it was a 0.126, which obviously that's a big difference. So I've noticed a couple people like that were in court that had the same BAC levels as well. So I'm just trying to protect myself and at least try to get the paper, and I'm hoping nothing got damaged during the move. But I was dealing with some domestic violence and got myself out of that and now in a hotel. But I'm just trying to make it through with 3 children and a dog. So I'm just doing the best I can, and I do apologize I haven't been able to just get this done right away and just send the information towards Destiny. So.
All right. I had, when I printed my list, okay, we only have the one case on Catherine Mann. That's 25 TR 170. But then I see there is on her Odyssey record an El Dorado 2025 TR 1796 pending. But that's driving while suspended as well. I don't understand where your BAC comes to play in this. Are you saying that that's why you were suspended, was a DUI?
Yes, ma'am. It was a DUI, and I, with the other account that happened in Kansas, that was on my way towards Oklahoma to see, we'll have my daughter see her father for 4th of July, and obviously for my very first road trip, I got a ticket on the first day and hit a deer in Burlington in Colorado, and then obviously was just hating myself for ever driving there because I didn't know that I had a suspension. And then obviously once I was aware, I was just trying to get home, and obviously thankfully the officer did let me leave and didn't impound my car or imprison me, but it was obviously due to the fact that I had my daughter with me that there was some leniency, and I do appreciate you guys for giving me that opportunity because I was just trying to do this for her father, and now obviously I will never do that again. You guys will never, obviously once I got back into Colorado, like I have been just using Metro buses and using rides from friends, and it's been really hard until I can get that paperwork, but I obviously due to the not being able to work like I used to, I am not really able to like get things taken care of.
I'm going to kind of draw you back into the matters at hand that may or may not be related, but right now we have limited purposes for being here. So you said you have a DUI in another state that got you suspended, and you're challenging that right now?
Yes, because the officer falsified the BAC level.
Okay, did you say you have an attorney looking into that or not?
I have an attorney for that, yes. But that was a court-appointed one.
And are you saying he falsified it, or he just didn't take into consideration that you were diabetic?
He falsified because there's two different BAC levels, and then he wrote two different speed, because he originally pulled me over for speeding.
Okay, let me stop you there, because again, we don't need to take that all up today. Are you going to apply for an attorney in this case, or hire an attorney, or waive your right to an attorney?
I would like a court-appointed attorney if I can't do the. Am I not still doing the diversion? I'm confused.
Well, if you have 2 driving while suspended pending, and you have a DUI in another state, I don't see it on your Kansas court file.
Well, it's because it's in Colorado, and I'm currently fighting for that, so that's why it's probably doing that.
Well, I don't see that you're going to probably qualify for diversion. You can look into it, but I don't expect you to probably qualify.
I mean, I know at least the other location, they're giving me that opportunity, so I was just truly hoping that you guys could do that for me at least.
Well, you and your attorney can look into that unless you don't want an attorney.
Well, the other location doesn't have the priors, and it also doesn't have Jay Regier as the prosecutor. But good luck with that.
But do you want a court-appointed attorney, or do you want me to ask you about that?
Yeah, I would need a court-appointed attorney. I'm on ABT and WIC, so I really...
Okay, slow down. How much money do you make per month?
I make only $350.
And do you get that from the state?
From the state, I only get, I think, $250.
And is that in food stamp assistance or?
That's cash assistance. And then for food stamp, I don't know what that exactly is. I think it's roughly around 400 or something like that.
Okay,
it just significantly dropped.
Do you, in addition to the cash assistance and the food assistance from the state, do you have a job that gets you any money?
Holistic healing and online creating, and that doesn't make much, so.
How much per month do you get for this holistic healing job?
I have not been currently being able to book anybody, so currently $0 for that, and for anything online, it's only about $250, if not $350.
What do you do online? You make things and sell them?
I do OnlyFans.
Ma'am, are you a whore? Object.
Okay. All right. So $500 a month. And how much for rent do you pay?
I'm paying $418 for the hotel a week.
So you stay in a hotel. Okay. And that covers your electricity and so forth. And did you say you have a child also or not?
I have 3 children and 1 dog.
And who supports them?
Myself and a little bit of their father.
I'm going to find that you do qualify for court-appointed attorney. I will appoint attorney Darren Patterson. His number, are you ready to write it down?
I'm trying to think of where my pens are right now.
Always, everyone, bring a pencil or pen to court. Always.
I'm just going to go and text it to myself.
All right, are you ready to text it to yourself?
I mean, if you're doing, excuse me, if you're doing OnlyFans and still qualify for a public defender, that's not a good sign. Although it is a perfect Darren Patterson client.
Yes, I am ready.
All right, it's 3, 2, 1. 7700.
I don't know the first three. I'm not from Kansas. I'm so sorry.
Okay,
The
area
first
code-
time I went to you guys, you gave me 2 tickets, so I'm just trying to. I just don't know it.
Are you ready? Area code 316 322 7700.
Okay. 316 322 7700. Right.
Miss Destiny, that's correct, isn't it? 322 7700. What's that?
It is, Your Honor, 322-7700.
All right, thank you. All right, now then, Miss Mann, you need to call Mr. Patterson as soon as the court is over and get set up to talk to him about your case. But you need to also go into a breakout room with court security too. Deputy, that's what you're showing, right?
Yes, Your Honor. And Your Honor,
Mr. Regier,
the state does wish to be heard on the issue of bond at the appropriate time.
this is appropriate. Go ahead.
Your Honor, in addition to the statements made on the record today, it would appear that this is a defendant who, pursuant to the ticket in this matter appears to refer to an address outside the state of Kansas. Additionally, if the court is prepared to accept a proffer, it would appear that in Ellis County District Court case number 25 TR 1796, there was a prior failure to appear pursuant to a journal entry of first appearance. Looks like that was back in August of this year. Therefore, the state is
Oh, Regier's looking this stuff up mid-call. I love it.
recommending a $3,000 bond. State has no objection to an OR bond.
All right, I'm gonna, Miss Mann, you need to put your camera back on.
Okay.
All right, Miss, I'm gonna
And that
set you
was
back.
currently because of the domestic violence that I was dealing with, and I showed the documentation to that, the county, so that they could take care of it and obviously give me a new court date. So I resolved that situation.
All right, so I'm gonna set your bond at 3,000. You're not gonna have to put the cash up unless you fail to come to court, and then you'll owe that to the state and have a warrant for your arrest. So make sure you're here at that date that I gave you, or I'm going to give you, which is when.
So you guys are making me come physically now.
Okay, stop right there. We're not doing anything to you, Miss Mann. You brought this
I'm
on
asking a
yourself.
question.
You brought yourself on this yourself, or perhaps the officers did lie. That will be determined at a later date. But I did not go out looking for you. No one in the state of Kansas, other than perhaps officers enforcing traffic, went out looking for you to drag you in here. Now, if you want an attorney, I'm going to have to give you time to talk to that attorney. Why give you an attorney if you don't want to talk to him, if you want to take care of it all right now? You see why I need to set this over?
I'm not sure you're actually understanding what I'm asking. I'm asking if I need to physically come into court, like Kansas, or if I'm doing Zoom still. I'm not asking for anything else. I'm not asking for a lawyer. I'm just literally asking if I'm coming to court, because you guys are saying I'm having an OR for 3,000. So I'm just trying to comprehend this so I don't miss anything.
Okay. Do you or do you not want a court-appointed attorney?
I already wrote down the number, so I thought that was what we're doing, so I'm really
I'm
confused.
asking you a question.
Yes, I want a court-appointed attorney. That's what I thought we were doing, so that's why I'm really confused.
Okay, that is what we're doing. I did appoint Attorney Darren Patterson, and I gave you his number. But if you want him, we have to set this over to another date. And I was getting ready to ask Destiny what date she has for you to come back. Where can you fit her on the schedule, please, Destiny?
Your Honor, I have December 29th.
December what?
29th.
Miss Mann, please don't talk over her because I can't hear her. What was it? One more time.
December 29th. 29, Your Honor.
Okay, December 29th, 2025 at 8 a.m. You must be back here by Zoom, Miss Mann, like you are today.
All right.
Is that a big
Yep.
inconvenience?
December 29th at what time?
8 a.m.
8 a.m. So it'll be 7 a.m. in Colorado, right?
I don't know. You tell me. I don't know what time you are right now.
It's 9:34. So what time is it there, ma'am?
10:34.
All right. Thank you so much.
All right. Well, hopefully that won't be too big of an inconvenience for you. But if it is, you still have to live with it. Now, this is the part you're definitely not going to like because Kansas law says that anyone charged with an A or B misdemeanor or higher, which are the felonies, must be fingerprinted and have their photo taken. So you're going to have to come to do that at some point. Now, the officer will work with you on when you do that. And you will have to have a $3,000. Is that what you recommended, Mr. Regia? $3,000
Yes, Your Honor.
A $3,000 bond. You will not have to put the money up, but you will have to get your picture and prints taken. And you have to sign a bond acknowledging that you know if you fail to come to court, that bond can be forfeited. You could end up owing a judgment. You won't put the money up, so it'll be a judgment, basically, to the state of Kansas, and you'll have a warrant for your arrest. So does that confuse you, or does that make sense? Do you
No,
understand
that
me?
makes sense because that's what Ellis County had told me to do. That's what I did with Ellis County. So am I able to do fingerprints here at my location, like nearest to me in Colorado Springs?
I don't believe so. You'll have to check with the deputy, but I'm going to order that you do it in person so that they know the person given the fingerprints is in fact the person that says they're given the fingerprints. I have not found a way around that.
Well,
So-
I mean, I don't know how Kansas works, but I mean, we just go to the police department and they have the scanner, so I don't really know how else they do it there. So
Well, I will say the officers to have my authority to do it if it can be done. Otherwise, it's my order that you do it in person if they can't work it out between the Colorado and the Kansas agencies. And I don't think they can, but that's where we are on it.
because currently they're not wanting me to leave the state, so I'd have to get permission to do that, even to do that. So
Okay,
I would have
so
to
let
make
me
sure
see if I
to.
understand. You live in Colorado,
Yes,
but you
I
have
was visiting Oklahoma for
Okay,
my
stop.
daughter's father.
All right, so you live in Colorado, but you came through Kansas on your way to Oklahoma where your daughter's father lives.
Yes, for 4th of July.
All right, and you got a DUI. Was the DUI in Ellis County out west?
No, the DUI was in Colorado Springs, El Paso County.
All right, so you got a DUI in Colorado, and is that the one that you can't leave Colorado on?
Yes, ma'am. I would have to get permission if that was the case, if I had to go physically into Kansas.
Okay. Are you on probation in Colorado?
I am not on probation. They have not made that. And more than likely, they would probably do unsupervised because of me being in intensive probation, because of other things that have happened to me in the past, from domestic violence, having my jaw shattered apart from a shotgun in October 10th of 2018. I have been in group homes and foster care, so I was in intensive probation due to that, so that the probation officer can be able to give me the best resources to be able to
Well,
not
I don't need all of
reoffend.
that. Thank you. I don't need all of that. But I just want to make sure I understand what kind of a risk you may or may not be on bond. So you live in Colorado, you're on bond in Colorado that says don't go out of state. Is that correct?
Yes.
So you'd have to get permission from your Colorado judge to come here to give your fingerprints and sign your bond, right?
Yes.
Okay. And then you've got a driving while suspended in Ellis County that's still pending, and you have a driving
Yes,
while
they're giving me a diversion right now.
and you have a driving while suspended here pending. And then did you say you got into some issues in Colorado or in Oklahoma or not?
No, I was very well. Once I got to his house, I made sure that I was only being driven.
You were what? I'm sorry, I heard someone
I
else.
was only being driven by the father and their family. I was not letting myself make more of an ignorant decision. I was just trying to let my daughter see her father because he hadn't seen her for months, and I felt really bad, and he was going through stuff. And so I was just trying to be a good mother and like a good person to him. So I obviously got in trouble.
So she's a saint, other than driving drunk with her daughter in the car. I think that's what we're to understand here.
Trouble for that, and I will never make that mistake again. So I'm just trying to get everything taken care of, and that's why I said I had to go through a storage unit after all the domestic violence I went through. And obviously
Hold up. Okay, so you were violating a protective order down there in Oklahoma. Is that what they charged you with, or they didn't charge you with anything in Oklahoma?
I was never charged in Oklahoma with anything. I never did anything wrong in Oklahoma.
Okay, all right. So we got that clear. Mr. Regier, was there anything else you wanted to be heard on?
Nothing further, Your Honor.
I am going to set the bond at 3,000 OR since she showed up today by Zoom. She can show up by Zoom at the future hearings. You must contact Darren Patterson and tell him your court date and your contact information so he can help you. And then...
Can I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
Go into the breakout room as soon as I'm through talking to you. You'll get an invitation to breakout room on your screen. Click on that, go into court security 2 with the officer and set up a time to do your picture and prints, and then call Mr. Patterson in that order.
Okay.
All right, so be it. Anything from either party?
Not from the state, Your Honor.
All right. Thank you, Miss Mann. Look for that breakout room. All right, let's take up Mr. Tapia.
All right, court calls the people of the state of Michigan versus Bobby Lee Du Bois, case number 253691 FY. Appearances counsel, starting with the prosecutor.
Joanne,
Also, Alyssa's fault and really doesn't get any better.
carrier for the people.
Good afternoon, Your Honor. Harai Diego Sapir on behalf of Brandon Du Bois.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case. Mr. Niegos, I know you had mentioned some issues before we actually got the case called. Is there anything you'd like to address on the record?
Yes, Your Honor. I would just ask my client to confirm. We had a discussion yesterday. He indicated some concerns about a potential change or a request that the court recuse itself such that a different district court judge would hear this matter given the court's prior employment status. In my discussion with Mr. Du Bois yesterday, my conclusion was that it was insufficient to even make the request, but I would just ask for the court to ask of my client at this point in time, or allow me to ask him, basically, Bobby, do you want me to ask the court
Forget about it.
to recuse itself at this point in time based on what you and I spoke about last night?
I do, and there's a couple other things that I would ask the court to hear me on before that as well. I'm not sure if the court is aware that there is an open investigation on the said officers that.
Okay. No.
Not aware and don't care.
No. We're not gonna do that. I'm on Zoom. We're not doing this. So if you believe that because Judge Wiggins was the prior Wexford County prosecutor and had worked in the prosecutor's office, are you asking me that I ask that he recuse himself, knowing that there's going to be a new judge that's going to be presiding, likely Judge Ransom, which is going to mean additional delays just to have this hearing done? You understand that?
I do.
Judge, based on my client's discussion yesterday, based on his representations today, understanding how clairvoyant and I guess that's not the right word, just how candid and transparent this court is in terms of its beliefs. I'm not sure ultimately, Mr. Du Bois is of the opinion that, he was previously prosecutor or attempts at prosecution were such when you were either the elected prosecutor or you were an assistant prosecutor. Based on his representations and his concerns on record today, and the fact that he's telling the court he understands this is going to be additional delay in proceeding to a preliminary exam, I would ask that the court graciously recuse itself, and I assume Judge Ransom would be the step-in judge.
Ms. Carey?
Well, I don't think there's anything specific in that request other than that you were the prior prosecutor, and I don't think that alone is enough for you to recuse yourself, and it sounds a little bit like judge shopping on the defendant's part, frankly. So I would ask the court to deny the motion.
Thank you. Defendant's request for me to recuse myself is denied. I do not believe I have a conflict in this case nor a reason to recuse myself. If the sole reason to recuse myself was because I have a defendant in front of me in which I was the prosecutor prior, I will say, other than maybe one judge, there's not a judge in this 2-county area that would be able to hear the case. Additionally, I don't believe just because I was a prosecutor, both elected and a chief assistant, doesn't rise to the level of being recused. I will state before that I was a public defender. I will also state that while I am familiar with Mr. Du Bois' name, I can honestly say I do not remember one case that I prosecuted him on. So I don't believe we've risen to the level of a need to recuse myself.
Yes, Your Honor. Thank you.
Mr. Niegos, are you requesting to move forward then today with the preliminary examination?
Yes, Your Honor, please.
Any additional matters before we start?
I would just ask that the witnesses be sequestered.
Ms. Carey, do you have any witnesses? All right.
I don't.
I will order that any witnesses be sequestered. I will also state for the record, because we didn't do this before, Mr. Niegos appears by Zoom and Mr. Du Bois appears by Zoom from he appears by the Wexford County Jail. Due to some threats that were made last week, the court felt it best for court security purposes to conduct this hearing by Zoom. Ms. Carey, your first witness.
Thank you. The people called Deputy Shane Rojas.
Your Honor, can me and my attorney have a moment in the breakout room, please?
Mr. Niegos, you want a moment?
Yes, Your Honor.
All right. All right, court recalls the case of the people of the state of Michigan versus Bobby Lee Du Bois, case number 253691FY. Mr. Niegos, have you had the opportunity to discuss matters with your client?
I have, Your Honor. I didn't get a full and complete opportunity to explain to my client what I'm about to say on the record because I didn't get a chance to speak. But essentially, my client's request is as follows. He wishes me to ask for an adjournment of this matter because he has initiated as he calls, an investigation into the actions of the primary troopers who investigated him in this event. He believes that the results of that investigation are paramount to his ability to present a defense in this case. He's also instructed me to subpoena some guards from the local Wexford County Jail for, at this point in time, I'm not sure what reason that would be towards a preliminary examination, but that's nonetheless his request. And the thing I didn't get a chance to tell him is to remind him that as this entire proceeding is now pending, he has no bond. He will have no bond. He's sitting on dead time. There's a parole hold on him. And whatever this MSP investigation that is or is not happening, he believes that it is. I have no information or knowledge of, nor do I believe it's paramount to my ability to effectively represent him in this case. That being said, my understanding is he wishes me that I ask for this adjournment, which I'm doing at his request against my advice. And I would ask that the court ask him directly if that is in fact the case, if he doesn't.
Actually, this attorney is really very reasonable.
The fact that this examination be adjourned once more even though I'm here prepared to go forward today, despite his earlier complaints about how long it's taken to get all this here. Thank you, Judge.
Mr. Du Bois, your attorney has placed on the record your request. Is that your request?
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter, and I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it could be pertinent to what we have going on. And I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's going to be wrongdoing found, I believe.
So, Mr. Du Bois,
in regards to this.
what is the nature, and I don't want you to get into the facts of it, but what is the nature of your complaint to Michigan State Police?
It's not the Michigan State Police, it's Deputy Roloff and Deputy King of the Grand Traverse County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King.
Are you alleging
In
that they're
regards to the
untrue?
drug, in regards to the possession. I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
Absolutely not.
All right, Ms. Carey, any argument?
And can we have Ms. Chandler subpoenaed to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know some of that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week, and I don't want to have them come back for the 5th time next week. So if we're going to have it investigated, let's not schedule it until we're certain that investigation is over, then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation. And I will admit, it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But are you guys able?
I mean, I am.
The court and staff are willing to,
This,
if the party, Mr. Du Bois, it's my turn now.
yes, sir.
If the parties are willing to hang over, we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough. And now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you didn't have a prelim last week because of your own actions. And now you're asking for another an
one
adjournment
time
today.
that I did.
And
The one
I'm
time
not,
that it was my fault. My child rights are being violated and you're just letting it happen. That's why Ransom was gonna throw it out the first time. What do you, like, I'm not being heard. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. Like, how am I getting an unbiased fair chance here? Furthermore, like I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me. At this point, I would like to dismiss Mr. Niegos under the, like, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions again, for the officers. Like, none of this stuff. I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are. And every time I don't, I get pushed through this system and I get screwed around. I do. Like, and the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos.
I'm sorry,
Judge.
it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Your Honor, I obviously I'm yammering and stammering. I'm not entirely sure what to say. He's representing, he knows his rights. He's representing, he tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the note from last week. He indicated he was not referring to me or my firm. As such, I was going to continue with him based on his representations here today. I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, I take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
Nicole, what about the interview between us that was scheduled yesterday? You've missed two.
Okay, Mr. Du Bois, Mr. Du Bois,
with
this
me.
is the perfect example. He's saying that the communication process is broken down. He wants out, and yet you want to argue with him. Why, I don't know, but you want to argue with him about
Because I
that.
want it on record why. I'm not just being disruptive. I'm stating what's going on. I should have an attorney that can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, the lawyer sees them for 5 minutes, they don't go. How much time have you spent on my case? Tell me some specifics in it. Your Honor, nobody can. That's why I'm raising such a fit about this. It's unconstitutional. You tell me that I'm getting a good defense by one of these lawyers that spend no time. He's on Polycam. We have not sat down one time and went over any part of my case. Not one. You tell me how that's constitutionally right and fair to my fair and speedy trial. Am I right to be represented by a decent attorney? I don't understand why you guys can't see what I see and what other people see. I don't get it. I'm not trying to waste time. I'm not trying to be disruptive. And you know what? I take full accountability for my actions, why I'm in these chains and
No,
why
I wouldn't
not
say
taking
that.
last
I
week.
wouldn't be saying anything about accountability or why you're in those chains before you fire me formally. Don't say that.
I want an attorney that will come here, sit down
All
with
right,
me
Mr.
and
Du
go
Bois,
over my
let me
case.
ask you a
Or
question.
I can,
Mr. Du Bois, let me ask you a question.
yes,
Do you
sir.
want an attorney or do you want to represent yourself? Because you've said two different things now.
I want an attorney that will come here and that will go over my case and give me the time and respect that I get.
I have no control, Mr. Du Bois, I have no control over who the public defenders appoint. I have no control over how they conduct their interviews. I have no control over that. All that has been removed from the court back during the reforms that started the Indigent Defense Commission. I have no control over that. All I can do is, it sounds like, based on what Mr. Niegos has told me and what you've told me, all I can do is order that Mr. Niegos is removed from the case because there's been a breakdown in the attorney-client privilege. You might get Perry Mason next time, or you might get Barney Fife. I can't say who you're gonna get next time. But I do not have an endless supply of attorneys. Do you understand that?
I do understand that, and I don't, like, am I not entitled to a good defense? Am I not? 5 minutes
are
before
entitled
we
to a good
come
defense,
before
but
you, Mr. Wiggins? Go ahead, sir. I don't want to interrupt.
Thank you. You're doing a very interesting job of not showing that. As I said, I have no control over who is going to be appointed to you. And yes, you do have the right to counsel, but you also have the right to hire your own counsel if you are not happy with the counsel you're receiving. And where you're indigent, which is what you are, I can't just go start knocking on doors and saying, please represent this person. There are attorneys that are under contract and under hire with the Wexford Missaukee Public Defender's Office. I have no control over that. So I'm willing to release Mr. Niegos. It sounds like he's in favor of that. It sounds like you're in favor of that, but I have no control over who you're going to get next.
But
I want to make sure you're
don't
clear.
have control over how they conduct what had, like, 5 minutes to go over. We haven't went over anything in my case. Nothing. Don't you have, can you point me in the direction of who to complain to? It's not my fault I'm indigent. Like,
I completely agree.
Who
It's
can
not
I complain to so I can
it's-
get proper and adequate representation?
Mr. Du Bois, if you would give me 5 seconds, can
I
you
am.
do that for me?
Absolutely.
You can contact the public defender's office here. They can direct you in a way to make a complaint. As I said, this is not the old days where the court had control over the public defenders. I don't do that. I have no control over who gets appointed, the directions they take a case. That has been entirely removed from the court. That's between you, the state of Michigan, and the Public Defender Indigent Defense Commission. But based on what I'm hearing today, I will remove Mr. Niegos from.
You have a good attorney now, dummy. But whatever. Try your luck with a new one.
This case. We will make another referral to the Public Defender's Office for the appointment of an attorney. We'll get everybody back here, but I'm not going to set it for next week. I'm going to put this off until it's going to be, and I'm not going to reset it for a probable cause conference. This case has gone on long enough. It's going to go right back to the preliminary examination. So because of that, I'm going to set it out a little bit longer. We'll go out at least 2 weeks. In the what?
28th of October.
The 28th of October. If the parties can agree and the court finds there's reasonable grounds to put this back on for a preliminary or a probable cause conference, I'll consider it. But it's going to go on the docket as a preliminary examination. Nor can I even guarantee that by the 28th, you'll have an attorney. I had another case today that's been almost 2 weeks, if I recall correctly, that they're still waiting for an attorney to take the case. So just so
at this
you're aware
time,
of all
can I
that.
represent myself until then?
I have to be convinced, hold on, before we go any further. Everybody in the audience, I'm sorry, we're now over our time. We're going to have to adjourn the prelims for this afternoon, and we'll get them rescheduled for another date. They're going to be rescheduled for 2 o'clock on Monday, the 20th. You can go out to the front windows where you checked in and get your next court dates. Again, I apologize, everybody. It just ran longer today than what we'd anticipated. So, Mr. Du Bois, back to you. I need to be convinced that you are able to represent yourself. Yes, you have a constitutional right to represent yourself, but that's not an all-encompassing right. The court has to be, and you can let the jail go as well. The court has to be convinced that that is a knowing and voluntary waiver of your right to an attorney, and that you have the wherewithal to represent yourself. So before I go ahead and do that, we have a process we're going to have to go through, but I want to be very clear. Are you asking to represent yourself, or are you asking to have court counsel appointed or indigent defense counsel appointed?
I'm asking to be able to have the resources to represent myself and look into my case law, and reference those things until an attorney is appointed so I can better represent myself.
Well, but see, therein lies the problem, because you can't represent yourself in between time of an attorney being appointed. If you've requested the appointment of an attorney, the attorneys can't talk to you, and I can't talk to you in very limited circumstances until you have an attorney appointed. So that's why this question is very clear. Are you requesting the appointment of an attorney, or are you wanting to represent yourself? You can't have it both ways, just so you're clear on that.
So I can't be granted access to a good legal law library so I can actively participate in my case until I have.
You can do your
defender.
own. You can have access to the law materials, but because you've requested a court-appointed attorney, you can't make any filings with the court, and you can't have any communication with the court or the prosecutor's office, except in very limited circumstances.
Okay. Yeah.
Does that
I
make
would like
sense?
to try to get an attorney a public defender that I can work with and that will come here, and to save time for you in the court. All I'm asking for is an attorney to come in, review my case with me, take an interest in my case, so I feel like I'm adequately represented, because at this point, I don't feel like I have been. You can't adequately represent somebody 5 minutes before they go into court, Mr. Wiggins. That's been my whole thing. That's been my whole case. That's why I'm frustrated. That's why I'm an animated person by nature. Anybody will tell you that. The people at the jail, anybody that knows me, I'm animated by nature. I don't mean disrespect by it. And yes, I do get on a rant sometimes, and I am long-witted, but that's because I suffer from disabilities. That's just what it is. And I'm sorry that you feel like I've wasted your time, but this is important. This
As
is
I
my
said,
life.
you're not wasting my time. As I said, I'm here all day, 5 days a week. But now Mr. Niegos, I've released you, so if you want to go, you're more than welcome to do that.
Normally, Judge, and I do apologize to your staff, especially since the time. Normally, I don't respond to these kind of comments because he's not the first nor the last that says these things. But in this case, given the documentation we have in our file and the comments he made, I just would like to put on the record that we've attempted multiple, albeit remote, jail visits. The first one was conducted with my legal and with my research and writing specialist, who does all of our
when they didn't show up. When they didn't show up, it's documented.
Mr. Du Bois, you had your time. Now it's Mr. Niego's time. You made all kinds of accusations against him. Now it's his turn to defend himself.
Yes, sir.
So the first attempt for a virtual visit, which is always the initial visit that we handle to go over the police reports and the initial things, happened on October 13. The notes in the file. This was also a case that I accepted on short notice. It actually occurred on October 2nd. I apologize. And and the notes in the file indicate that essentially the visit was conducted and was terminated due to Mr. Du Bois essentially not liking what he heard in terms of what potential defenses and such he may have had. Another visit was then scheduled for yesterday that Mr. Du Bois is referencing. He and I spoke on the phone last week. The sole purpose of that visit was to discuss the note from last week and whether or not I would stay on as counsel for him. And during our phone call last week, he and I agreed, or I agreed at his request, to stay on. And finally, the last point, Judge, in terms of what we did or didn't do, as he can at least attest to this, he's got copies of his police reports. This is a preliminary examination. I spoke with him. The anticipated outcome of the preliminary examination and the anticipated motions we're going to be seeking to file in court. The bottom line is this, Judge. This is an individual who knows the laws and knows his rights after he allegedly committed crimes. And at this point in time, it's, of course, his defense attorney's fault for him not adequately being represented. I was ready to conduct this preliminary examination. I've explained to him the motions that I anticipated filing based on my assessment of the case that would have led to a bind over, given the evidence in this case. He doesn't like what I had to say. I respect his wishes. I wish him nothing but the best. But in terms of the representation, and it's not just me. I have people that are very helpful, that work very hard in our firm, who try to do the things that we do. And a lot of what we do is service communities like Wexford, communities like Missaukee, communities like Sheboygan, places in northern Michigan as well as southern Michigan, where frankly there are not many standard 7 qualified attorneys to handle capital life felonies. My firm does an abundant amount of appointed cases by choice, not by need. And I wish Mr. Du Bois all the best with whoever other public defender or conflict attorney on the roster accepts his case. Thank you for allowing me to put that on the record.
Thank you. Now, Mr. Du Bois, you raised another issue, and that is a friendship between Ms. Carey and myself. And yes, well, Ms. Carey and I had worked together for a number of years. She was also my chief assistant prosecutor while I was the prosecutor. And yes, we did have a friendly relationship. But I will state, since becoming judge, I don't want to say that friendship has ended, but as far as Ms. Carey and I doing anything together, that has not happened at all since I was judge. The most time we spent together was a couple of weeks ago at a conference with 4 other persons, including Mr. Champion, the chief public defender, and the community corrections director. So as far as your allegations that I can't be impartial because of a friendship that I have with the prosecutor, I don't find that persuasive. I've ruled against Ms. Carey in a number of cases as the judge, and I've ruled in favor as the judge. I've also ruled in favor against all the other prosecutors. We're in a small community, and unfortunately, that's how small communities work. But I have the ability to separate myself from any friendship that I have with somebody to make sure that justice is carried out. And if you aren't feeling that that's being done, I apologize for that. But that's simply how it is. But you can certainly raise these issues with your next attorney once they get appointed. And if you feel and that attorney feels there's need to go ahead and file a motion to recuse myself, I'll certainly hear that motion again.
I have one now. I've written it myself. I tried to follow.
But Mr. Du Bois, you requested the appointment of an attorney, so the court can't hear that motion.
Well, but I asked him to do that before this, and do you see the problem that we keep running into?
But again, that's water under the bridge. I'm just telling you, moving forward, you can discuss that issue with your next appointed attorney. All right?
Okay. Yes, sir.
Okay, we are adjourned.
All right, brother.
And then we are on the record in the matter of the City of Wyandotte versus Corey Schmitzer, 251453 A and B.
Boy, here on behalf of Corey Schmitzer. Ms. Schmitzer, can you hear us? Would you please state your name?
Yes, Corey Schmitzer.
Thank you.
All right, and good morning. Today is the date scheduled for the arraignment as your client is in custody and asked the arraignment
My
counsel.
client waived formal reading and stands mute to the charge.
Court will waive formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial October 29th at 8:45 a.m. And counsel asked to bond.
client advises that she's never failed to appear for court. She's got in a rough patch of her life, Your Honor. She does not have consistent residence right now. Be open and honest with the court about that. She advises that she will return. She will follow any and all the court's direction. We ask the court to take that into consideration, setting a reasonable bond for her.
Okay, and ma'am, are you working?
Not at the moment, but I'm supposed to be this Wednesday, have a job interview. I forgot about.
Ma'am, did we wake you? Are you tired or do you have a back issue?
Stand up straight.
Yes. All right. Yeah,
Stand
my
up,
hips.
thank you. What?
Yeah, my hip hurts really bad right now.
Okay, well, ma'am, if you're to test right now, what is in your system?
What was that?
If you are to test right now, what is in your system?
Marijuana and probably a little bit of that substance from a while ago or a couple of days ago. Marijuana and a little bit of that substance from a couple of days ago.
Okay, what would the substance be, ma'am?
Your Honor, I'm going to interrupt here. Ms. Schmitzer, please don't answer that question. I'm going to go to the root of the charge.
Well, that's correct, counsel. That is a possession charge, so, all right. So, ma'am, are you currently, well, let me clarify that question. Have you ever failed to appear in court for any reason?
No.
Are you currently on bond in any other jurisdiction?
No.
Are you on probation or parole anywhere?
No.
When's the last time you were employed?
Just about literally a week ago.
And where were you working?
Dollar Tree.
Sorry, Dollar Tree?
Yes.
And you don't really have anywhere stable to live?
I was staying at a friend's house.
Well, if you were to be released, ma'am, where would you stay?
At my friend's house that lives near here.
Which is where, ma'am?
Shoot. It's like a Detroit Ecorse borderline.
Okay. Well, here's what the court's going to do. The court's going to, based upon Ms. Schmitzer's lack of stable housing, the court's going to order a $3,500 10% bond on count B. 30. And you're not to possess or consume any alcohol or drugs unless prescribed. And then we will see you back on October 29th. Thank you. Have a good day. All right, let's go off the record.
Okay, good morning.
Morning, Judge. Yeah, so the judge, this is Mr. Van Wagner.
All right. Good morning to you, Mr. Van Wagner. And Ms. Talina, if we're ready to proceed, go ahead.
So in speaking with Mr. Van Wagner, it sounds like he is ultimately probably going to want to set this case for trial and fight it. He believes that he was acting in self-defense. He indicated to me that he got severely injured in this incident. And that anything that happened was just him trying to get a bunch of people off of him who jumped him. So
Well,
12
Yes.
people jumped me
So I
at this
do
point.
think,
12
yeah,
people. I'm
okay.
the victim here.
So obviously, Mr. Van Wagner feels very strongly about this and is going to want to exercise his right to trial. So at this point, I'm asking the court to consider a PR bond. We talked a little bit about his prior failure to appear. He indicated to me that he does have some short-term memory issues, but that since he's been in jail, he's been working with Focus Reentry, and he believes that they can help him make sure that he gets to his court dates and his appointments and remember all of that stuff and things like that. In addition to that, being in custody right now, he's pretty concerned because they're not giving him his appropriate meds as they've been prescribed to him. So I know he is feeling stressed out about that and is wanting to get out of custody so that he can take care of that. So for those reasons, I'm asking the court to consider a PR bond.
All right, Ms. Keller, would you like to respond?
Sure, Your Honor. The city would maintain our objection to a PR bond in this case. Number one, just the severity of the charge here, as well as Mr. Van Wagner's prior failure to appear. I do have some concerns that he will not return to court on this.
I swear to God, I will return to court. For one, you know this because your boss, Chris Reynolds, will make sure that I'll get to court. All right. I've been trying to turn myself in for this charge for like past couple days, actually a week before I tried to. I guess the jail was too full, I guess. I did try. I was here at the jail trying to turn myself in, which I was not able to. So I camped not even a couple of blocks away from here where they know they would find me. All right. And they found me, and I was put in jail yesterday for FTA for this and FTA for my other case because I did not have anybody working with me. I've sent kites to Focus Reentry, to BCAP, programs that I'm in, that they left me hanging without telling me when my court date was. I've asked them multiple times. They've left me hanging. These are court programs that you guys put in motion here that have let me fall through the cracks. When I got arrested last time, I had housing. I was in here for 90 days. I lost my housing because I was in here. Because of the due diligence of the programs that ain't doing shit for me. And I'm doing everything that they're asking me to do. All right? But you guys need to hold these programs accountable. And these programs are supposed to be helping me like they're supposed to be helping me if I come back. If you guys hold me here, there's nothing that I'm going to do besides go to detention. Because everybody knows that that's me. Because I'm not going to be able to get my medication for a month while I'm in here. Because they won't approve it. I need to be out. I need to be going to my doctor's appointments. I need to be taking my medication so my anxiety isn't off throughout the roof. I was jumped here, Your Honor. I was jumped here in the library parking lot, Your Honor, by 12 individuals, and I just fought back, and someone was bleeding from the head. And I did nothing besides push him away from me. All right? And his face caught offense, Your Honor. His face caught offense, Your Honor. And I did nothing to him at all besides trying to push him away from me. And I'm being charged, and he had 12 people jump me? He broke his foot on the back of my head, Your Honor. He should be in here. I should be out there. I should be the one pressing charges against him, which I indicated to the officer to do in the first place.
Okay, I'm going to ask you, just I'm going to consider your discussion here. I'm taking a moment to read through the history that I have for the defendant, including this case and other cases. And I'm also going to look at the report itself so I have an idea of what the allegations are based upon.
I wasn't trying to press charges on him, but he was trying to press charges on me. There was no weapon found. supposedly hit him with a weapon. There was no weapon
I don't want
found.
you to talk about your case, okay? Because everybody here, is
Ma'am, you've done nothing for me besides say what I wanted you to say. You are the worst attorney I've ever had. I'm sorry you guys had to
I'm going to
hear
ask you to stop speaking now so I can focus on what I need to do. And so I'm going off camera for a moment.
Sorry.
She's doing fine. She's trying to help. And she gets that you're the worst attorney ever.
You remember that night, don't you? The morning I went crazy. Banged my head against the wall. These charges shouldn't drop because I'm the victim. Bullshit. 12 people against 1.
I think this is a farce of misbalance of justice.
I'm back on camera with the defendant. Ms. Talina made the request for a PR bond for Mr. Van Wagner. Mr. Van Wagner made some additional arguments in connection with that request. I've looked at the prior history. In this case, there's one FTA in this case, and there's at least one other prior failure to appear in other cases and perhaps others. I only really looked at one case and knowing that there's been prior failures to appear. I also looked at the report. And of course, there's disputed facts in connection with the report, so the court can't pass any judgment with respect to the
I'd
allegation.
also like to put a warrant out for his arrest, Your Honor, for
I'm going to
his assault on
need you
me.
to let me finish speaking so I can make a clear record. I'm going to deny the request for a PR bond based on the nature of the charge and the prior failure to appear history. So we can go to a next step of accepting a not guilty plea and setting for trial. Ms. Talima, I'll let you, if you want additional conversation with Mr. Van Wagner before doing so.
I want a different attorney, Your Honor. She has no respect for me.
Mr.
I
Van
want
Wagner,
Chris Reynolds.
I've heard nothing.
I want Chris Reynolds, Your Honor.
Chris Reynolds represents the prosecutors. He
Yes,
cannot
I'd like to
represent
go
the defense.
against him and not against Keller.
You don't get to choose who the prosecutor is, and you can elect not to have counsel, but I'm not going to simply allow you to say that the counsel that's presently representing you
She's
is not
impotent.
capable. She's extremely competent, extremely capable. So I'm not changing the lawyer that I'm appointing in the case for you.
And I want my medication. That's the thing. You guys are gonna hold me in here without medication, and I'm gonna go crazy.
I appreciate the need for medication. I completely appreciate that. I don't have any control over the jail.
Yeah, exactly. You can't do nothing for me, Your Honor. You can only hold me here.
That's correct. But I have denied the request for PR bond. The cash bond will remain in effect.
So, Judge, I think I'm going to ask to bring him back on Monday so that we can see
I
what
want
happens with
back
this
on
state court
Friday.
case.
Friday or tomorrow. Friday or tomorrow, Your Honor, please, because I will get a PR for this drug case. Yes, I believe that the judge will grant me a PR for the small minor possession charge, Your Honor.
Now that I've
and
seen
that's
you-
the other PR.
Now that I've seen the defendant within the 48-hour period, I'm not resetting him for this Friday. I will reset for Monday if that's what defense counsel would like me to do. I'm not resetting him for Friday.
Let's go.
No,
Take
please
me
stay
to
there.
the D. No, I'm already and I need to go to the D now.
Go to what?
Go to detention now. Let's go.
Making a clear record for the defendant. We'll see him on Monday.
No.
Cash bond remains. You can go ahead, officer.
Hang on one.
Well, there you have it. A pile of crazy, and it really did. It just kept getting worse. It was a perfect Law Talk with Mike stream. Thanks for coming out. I appreciate it.